Now, in another judgment which could have implications for the gig economy, a bicycle courier has won an employment rights case. A tribunal found the courier with the logistics firm CitySprint should be classed as a worker rather than self-employed. A short time ago, the courier, Maggie Dewhurst, interrupted her celebrations and came into the studio. I began by asking her what prompted her to pursue the case.
The whole courier industry is built on a business model that means couriers are at arm's length, and the way they do this is through a legal mechanism in a contract, and it classifies us as subcontractors, which means that we are meant to be running our own business, and therefore the entire industry is subcontracting to thousands and thousands of little businesses, which you might remember in the Uber judgment was found to be totally bogus. They said there's no way Uber could be a mosaic of 30,000 small businesses. The same applies to the courier industry, and the reason a lot of these gig economy tech companies, apps are copying the model is because the courier industry has gotten away with it for so long. And the reason we needed to challenge it was because all of our rights are taken away through these contracts, and someone needed to be the pawn, basically, and I was that person.
Were you nervous? Was it something that you were fearful about?
Yeah, of course. It's really, really scary. One of the clauses in our contract says, or was to the effect of, you will never take us to court, and if you do, you must indemnify CitySprint of the cost, which basically means do it, but you're going to pay for it. So you better think twice about it, and you better be scared about it.
So you were terrified. What gave you the courage to go ahead and do it?
Loads of things. There was a lot of support in the courier community. A lot of people, once we explained the legal arguments to them, they were like, oh yeah, that's what we're meant to be. Because everyone rows about this all the time. Everyone knows that it's rubbish, that these contracts are meaningless, and that they're being deprived of rights. And there was also, through the union, the IWGB, managed to get pro bono lawyers, and they were like, yeah, we're going to help you for free, which is amazing.
So winning this tribunal means that you are now entitled to basic rights, including holiday, as well as the national living wage.
The right to the national minimum wage and paid annual leave is a really big deal, because a lot of my friends earn below the national minimum wage. After costs and expenses that they have to incur because of their job, then they'll earn below it. So that's a big deal. But the paid annual leave thing is a really big deal, because I mean, the judgment says I'm entitled to 2 days holiday, which is a technicality because of the process. But in effect, it means that, you know, people that have been in the company for 5 years, 10 years, 15, 20 years in some cases, they're owed loads of money. And this isn't about my 2 days annual leave. This is about the fact that thousands and thousands of people up and down the country that work for courier companies who are under someone's control, and that person is not a manager, they're called a controller. You know, it doesn't get much more controlling than that. They are owed not only rights, they're owed national minimum wage, they're owed holiday pay. They live every day, you know, am I going to have enough money if I come back from holiday? You know, all of that stress and anxiety that goes in with the job could be just relieved a little bit. We're not trying to make the job really easy peasy, but we're just trying to make it a little bit easier so that people don't have such a difficult time.
But is it the case that this judgment initially means that only you are going to benefit from it?
I mean, I haven't read the full judgment yet because I've been at work, but it depends how it's written. It might be written that it applies to all of us. I don't yet know, but it will require other people to lodge claims. But I think CitySprint know that their time is up. I think it's just dreadful that we have to go to court in order to do this. Like, they should have been paying people holiday pay for the last 20 years.
And you're going to stay with CitySprint?
Yeah, of course. I love my job. I'm addicted to my job. CitySprint are the best of a bad bunch. The industry is really, really awful. So I think it's time that courier companies just bite the bullet, pay people the living wage, pay people paid annual leave. It's not that much to ask, is it?
Maggie Dewhurst, a spokesperson from CitySprint, gave us this response. We are disappointed with today's ruling. It's important to remember that this applies to a single individual and was not a test case. We enjoy a good relationship with our fleet, as was clearly highlighted in this case. CitySprint is a good company that pays its couriers some of the best rates in the industry.